Great. Okay, so welcome everyone to, I think, our 6th Legal Lunch and Learn. My name is Martha Rance. I'm the Director of Programs and Interim Managing Director for the Pacific Legal Education and Outreach Society. And today we're going to be talking about commercial rent relief with Grant Haddock. Before we get started, a few things to be aware of and think about. First and foremost, I want to acknowledge that this is taking place on the unceded ancestral lands of the Tsleil-Waututh, Musqueam, and Squamish peoples, and that we thank them for their forbearance of our work on their land. Today, if you looked at the bottom of your screen, there are a number of icons. We have closed captioning available. I encourage those of you who need it to make good use of the facility to do that. And also there, you will note there is a question and answer icon. That is the icon that you should use for putting your questions in for Grant. I will be the moderator, and as soon as we're ready to take questions, I'll start bringing Grant, asking Grant, putting him on the hot seat, I guess you could say. And by way of introduction, Grant Haddock is a housing lawyer and a great friend of the Pacific Legal Education and Outreach Society. We've co-presented at the BC Nonprofit Housing Association conference and have similarly aligned practices of law. We're very, very fortunate that he's willing to give up his lunch, or maybe he's going to have a late lunch, to join us today. And I'll just turn the screen over to you, Grant.
Great. Thanks very much, Martha. I'm the principal of a law firm called Haddock & Company. We work predominantly in housing law, and we also are in the commercial tenancy world too, as it kind of lends itself to that. So we work mostly, or I myself work a lot in the nonprofit sector, mostly with nonprofit housing. The rest of the lawyers in my firm do a bucket of residential tenancy work, lots of strata property work, lots of nonprofit housing work, and lots of even the manufactured homes. And we do construction law as well. And then we do the commercial tenancies, which is what I'm going to talk to you about today. So today we're going to talk about, as long as technology doesn't fail me here, we're going to do, just share my screen with you guys. Come on, resume slideshow, hello, where are we? Oh, there we are. Why can't I? Oh, there it is, sorry. There we go. I'm going to talk about, everyone see this? Martha, can you see it?
Yep.
All right, rent relief for commercial businesses. Deep dive into the CECRA program. So I don't know who called it a deep dive, but we only have an hour, so it's going to be a shallow dive. But we'll do the best we can about this. So the CECRA program, first of all, just so you know, the government's still at this moment, because I'm watching the website across from my desk here, hasn't announced exactly what's going to happen yet. So we're still waiting for all the details and for the program to roll out and for people to actually be able to apply for this. So a lot of what we're talking about here is what you can find on websites under even CMHC or the federal government will have most of this information on there. But like with the assistance for wage subsidy for your employees, we don't know exactly what it's going to look like until they roll it out. So there might be some hiccups with the information you have to present, the acquired criteria of the qualifications. So what I'm going to show you today is what we know so far, but what might actually happen within the next few hours or tomorrow morning might look a little slightly different. So first of all, COVID-19, the biggest thing that's ever happened in our lifetimes probably, but the province has invoked the Emergency Programs Act to address the COVID-19 pandemic. One of the really interesting things is like hardly anyone ever talks about the Emergency Programs Act. It's this incredible act that gives enormous powers to the cabinet, who is able to make what's called ministerial orders that can change legislation, and no one seems to have a problem with that right now. And I suppose one day, if this drags on a long time, people will start talking about it more. But right now, we have gatherings of 49 people are not permitted. Certain non-essential businesses have been ordered to shut down. This is causing, of course, great difficulty in the retail sector because a lot of those stores must be shut down. A lot of them are not essential or non-essential, so you're not allowed to be open. The public is not venturing out to comply with suggestions, and they're good Canadians, and they're complying with suggestions to stay home and apply physical distancing. So I'm in my office today. That's the view you're looking at outside my office, but I haven't been here very much at all. I've come down like in the last 60 days, like once a week, maybe for a morning, but I'm starting to venture out myself. So people are going to venture out. We expect there'll be a loosening of restrictions from Dr. Bonnie as of after the long weekend. And hopefully we'll all be smart about things and continue our physical distancing. So for business impact, many businesses leasing commercial space are struggling with reduced or completely eliminated income. What are the options available? Yeah.
Hi, Grant. It looks like your slides are not moving forward.
Oh, okay. So
we are looking at just the
beginning one there. So I had this. I had this problem before. So what I'm going to do is this. I'm going to go back to Zoom here.
Sorry, everybody.
No, what you're going to get is you're going to get this instead, because this I think works. I think it does. Does that work? Are you seeing that?
Yes.
Okay, so
yes.
Right, you're gonna get this raw thing. For some reason, PowerPoint doesn't always like Zoom. So here we go. This is what you're gonna get is this. So try not to look to the right-hand side, because then you won't be surprised when I say something controversial. Okay, so CECRA, what does it mean? It means, or the acronym is Canada Emergency Commercial Rent Assistance. As I said earlier, it hasn't been rolled out yet. Details are to be expected to be released any day. What I thought was really interesting about this is to be administered by CMHC. I didn't think that was going to happen. I thought maybe it'd be administered some other way. I'm dealing a lot with CMHC on other things, like mostly with financing and stuff like that. And right now, for me to get anything done, it's completely impossible because CMHC is busy, I think, working on this, trying to figure out how it's going to roll out. But the way I've heard it's working is that, Justin Trudeau and his group will stand at the microphone and make an announcement and then say, and CMHC is going to administer this. And CMHC goes, we are. And then they are now commanded to go ahead and start this, which I think is why a lot of these programs, they sound really great. And then weeks later, it hasn't quite materialized yet. I'm not criticizing government because they've done a really good job of rolling things out as fast as they possibly can. This one, though, has taken a little bit longer than I thought it would. I thought for sure. They said mid-May. We're not really at mid-May. It's the 13th. So the mid-May is technically Friday. So that's the date after Friday. You can start complaining as to why this hasn't happened yet. So what is it? It's going to offer forgivable loans to eligible property owners, and I've underlined owner for a reason, if that owner will forgo or reduce a commercial tenant's rent. So this is the first controversy here there's a lot of people talking about it in the online and in the chat rooms and all that. It's an option for landlords, and landlords are not compelled to engage in the program. And if you don't engage in the program, well, you're not going to get rent relief for the tenant. So more on that later. I'll talk about that in a bit, about that problem. Oops. Sorry. How's it supposed to work? Okay, so rent assistance is supposed to work for the months of April, May, and June, and it's going to be retroactive. So even though your application isn't going to go until earliest third week of May, it's going to be retroactive to April. And then now, if you've been watching the news, you will note that the Trudeau government made an announcement that the subsidy for wages for your employees was April, May, and June, and now he's going to push it forward. He says now it's going to go ahead into July, and then maybe it's going to go August, September. I don't know, but that might happen with CECRA as well. We don't really know. So these are forgivable loans to the property owners, not to you if you're a tenant. It's to the property owner. And the deal is this, like very simplistic, but the loan from the government covers 50% of your gross rent. So if it's $1,000 a month you're paying, the government's going to kick in $500. The tenant's going to pay 25% of the gross rent. So you as a tenant have to find the money somewhere to come up with 25% of that, or $250. And the owner eats the 25%, another 25% of the gross rent. So the owner is just going to not get $250. He's going to have to figure out some way to deal with that. So here are the requirements to qualify. The property owner must own commercial property that generates rental revenue. The property is located in Canada. That seems to be a no-brainer, but you never know. I suppose somebody's got some trust or something that might have maybe a small property here and something offshore or something. So maybe it's not such a no-brainer after all. There has to be an impacted small business tenant occupying the rented property. I kind of wondered if in April or even in March, what if a tenant fled the property? Can the owner then make an application of this nature? Again, not quite sure. There also must be a mortgage loan secured by the property. So if you've got as I'll get into this a little bit later, if your owner doesn't have a mortgage, then this program is not available. The property owner has to have entered or will enter into a rent reduction agreement with you, the tenant, for the periods of April, May, and June. That will reduce the impacted small tenant's rent by at least 75%. I read that and I went, how's that going to work? Because it seems to me like it's a contractual waiver that the landlord is making that says, okay, your rent is now 25%. Then how then do you ask for money from the government if your rent is like this? Because if you look at it from a lawyer's perspective, the rent would go down 25%. So what's the gross rent now? Is it 25% or the 100%? So you have to be careful about how you're drafting these agreements. So if the property owner is going to do this, it's not so much a tenant problem, but it's certainly going to be a property owner problem. You have to be very careful about how your rent reduction agreements have been put together. So I've, as part of our residential tenancy work, I put together a long and short form version of, we call them rent deferral agreements. And so those were carefully thought out as between residential landlords and tenants. And so far, no one's asked me to do the same kind of document for a commercial venture, but I suspect that's coming because one of the key aspects that you need in order to get access to this money is an agreement like this. So rent reduction agreement with impacted tenants includes a moratorium on eviction for the periods April, May, and June. Okay, that seems reasonable. The property owner has declared rental income on their tax return, personal or corporate, for tax years 2018 or 2019. So again, this is something that you as a tenant, you're not going to access this kind of information. You might wonder why your landlord who has a mortgage isn't making the application for the rental subsidy. Well, maybe your landlord hasn't been okay and upfront with the tax man for the years 18 and 19. He doesn't want anyone to know about that, especially the tax man. Who knows? These are things that you're not going to have access to, which is another problem with why this thing is really left in the hands of the landlords, taking control away from you guys as tenants. So what's an impacted business? So you got to have an impacted business. If you don't have an impacted business as defined, we'll get definitions later, but this is what we're told is what an impacted business is. You're not going to get access to these funds. So the business can be a nonprofit. So if you're a nonprofit, which I suspect most of you are who are listening, you're in this qualification. You pay less than $50,000 per month in rent per location. So if you have a couple of locations and aggregately you're paying more than 50, you're still okay. You generate no more than 20 million in gross annual revenues. And you've temporarily ceased operations or have experienced at least a 70% decline in pre-COVID revenues based on same months in 2019 or January, February 2020. So if any of you have made applications to get get access to the subsidy for your employees, it's the same test as far as decline, revenue decline, as far as the time periods go. So what you'll end up doing is you'll be looking at your revenues your 2020 revenues, probably from March 13th to April 11, which is the program period for the employee subsidy. So you'll take the March 13 to April 11, 2020 number, you'll look at that, and then you'll compare that to either one, your March 2019 revenues, like for the whole month, or an average of your revenues you brought in January, February 2020. So it's pretty easy to do if you've got uncomplicated accounting system, and they don't even ask you for that backup when you make the application. At least they don't on the employee side of it. When you're looking for the employee subsidy, you simply declare that you are you believe yourself to fell into those categories, and your revenues fall short. And in this case, you're going to say like your 70% decline. The interesting thing about that is, like, most people are doing it on their own. They're not having accountants do it, although accountants can do it. So I've always kind of wondered, well, what happens if you're wrong about that and you're actually, 69% decline rather than 70% decline, and because you're not an accountant, you just simply made a mistake. You might have to pay the money back, is what the government is saying, but I kind of wonder how all that's going to play out. So that's really in a nutshell, how the program is going to work for eligibility and how much money you're going to get. And there's not a lot more to it than that, as far as we know. But I'm looking ahead and looking at programs, or problems with the program. I think we've heard in the news, they were reporting yesterday that at least for the CERB payments, which is the $2,000 payments, the government has been asked to simply overlook possible fraud or possible mistakes or double payments, things like that, because they're just interested right now in just getting the money out as fast as possible. And then one day in the future, when we're all safe from the pandemic and things are back to normal, whatever our normal looks like in the future, then they'll be looking at whether or not these monies should have been paid out. So I'm thinking at the moment, like when you make the applications, no one's going to be looking very carefully at what you're doing. The money's just going to go out as fast as possible. We try to save businesses, so when things get up and running again in the fall or maybe next year, that everyone who could have survived this can survive it because of the government help they got. So problems. First one, we don't know what the program looks like as of at least this moment. So we might know by Friday, maybe tomorrow by Friday. It may have come too late to save some small businesses. Some have just, decided they're closing. A lot of, like restaurants, especially with very thin margins, have said, well, it doesn't matter what you do for me. I don't even have 25%. They're just going to say, well, it doesn't matter. We're closing anyway. So the program itself, and this is the biggest problem, it's entirely in the hands of the property owner. And this is problematic for various reasons. A couple of them I already stated. First of all, you might have owners who ignore the opportunity. They just say, they don't pay attention or don't seem to care. They're unconcerned about it or whatever. You have offshore owners. There's like not an insubstantial or unsubstantial number of commercial properties owned by offshore interests. Well, they've got their own house on fire back home. They're worried about that. They're not terribly concerned about here, can't really figure out the programs or don't have the staff or whatever is happening with them. So you might have offshore owners, if that's who your landlords have to be, if they're controlled, you're wondering why aren't they applying? They're just not interested. You might have owners who are looking for an opportunity to be rid of tenants, particular tenants, and they see, well, why am I going to help this person when I don't like them anyway, and I've had nothing but trouble with them because they've been asking for all sorts of help or this and that, or I want improvements, or the sidewalk's not clean. All this stuff, they might say, well, they're a troublesome tenant anyway. I'm not going to assist them through this. So I'm looking for new tenants. And this is a good way to move on to my next tenant. You have owners who are not willing to take a 25% reduction. And that's, someone will say, well, I'm not going to pay 25% and be compelled to do that for the next 3 months and perhaps 4 or 5 months. Because if they extend this benefit, which they've done from the employment side, maybe they'll do it for this side too. So owners might be sitting there going, well, okay, I'm not going to do that. Something I haven't put in there, which is a legal cost of getting into this, because you need to have that agreement, and that agreement should be in writing. And so owners are going to have to put the agreement together. usually them. They're going to have to pay probably someone like me to do it. They might not want to do that. Tenants, of course, should be hiring their own lawyers to look at whatever agreements are put before them, just to make sure they're okay. But there is a written agreement part of this, which is mandatory, which would seem on the face of it to make sure you got some good legal advice about what it was you're either preparing or what it was you're either signing. Owners not willing to support businesses that appear to the owner to be doomed to fail, either during the phase reopening of the economy or in the second wave of COVID that could hit in fall 2020. So right now, I mean, you might have an owner saying, this business was marginal to begin with. They're having trouble paying their rent. They're not going to do any better when there's a phased reopening of the economy. And if there's a second wave of COVID, I mean, God forbid, there might be in the fall of 2020, that would really be the demise of these people. Like, why am I going to continue my pain with this tenant and support them by, first of all, taking a 25% cut in what I can get, and then may or may not get the other 25% from the tenant over the next 3 or 4 months. Maybe it's time to cut my losses. Maybe it's time to have the place empty and use it as some sort of tax write-off this year. Because sometimes landlords, depending on what their money situation is and their tax situation, how they've set up their write-offs, it might be better for them to have it empty. That is a real possibility. Like, landlords can decide that we're not going to support these businesses because we don't see a real future in that. In fact, for a landlord, we see a situation where it might be detrimental to the landlord's ongoing business operations to try to support this tenant. You have landlords with no mortgages and they can't apply. Now, I've seen that there's a separate program. It's anticipated there's a separate similar program that's going to be rolled out for owners or property owners or landlords who have no mortgage. Now, I have no details on that. I've just sort of seen something that says we anticipate this to be happening. Just don't know when it's going to happen. This is a warning, and this is why you should be careful of what you sign. Someone, probably some smart, slippery lawyer, is going to figure out a way to devise a method by which landlords who are foregoing the 25% from the tenant somehow get it back again through some agreement. They were supposed to forego that, but maybe there's something like in the future that they might be able to take advantage with, and that's why you have to watch out for the documents that you might sign to move this forward. So the other thing is, like, you're gonna need a valid and enforceable lease agreement. Well, I don't know how many times I've had, thankfully it's not that often, but once in a while I get a client coming in and saying, well, we kind of did it on a napkin. Okay, that happens, or it's not in writing. It happens way too often is what I'm trying to say here. So you don't have a valid, like, your document that you have might not be a valid enforceable lease agreement. What if you never got your agreement in writing? You need that to apply for the program. If you never got around to it, I mean, today's not the day to ask your landlord, let's sign one, because then he goes, oh, hooray, I can maybe throw in a couple of terms that you didn't expect. So if you don't have a valid enforceable lease agreement, then, you know, your landlord might not be able to, or might not be willing to get into this deal. Because as I said before, the government's not asking for any proof of these things. They're just looking for attestations. Like on the website, you just sort of click a button that says, yeah, I certify this is true. And then if it isn't true, then they'll come back and get you at some later date, perhaps. And the big question I had is, I was trying to figure out what's gross rent. They say it's the gross rent. So intuitively you would go to, oh, well, it's the check I write every month to my landlord. Well, it's not really. I mean, if you look at your lease agreement, there's rent and then there's operating costs. And operating costs are what they call it, the triple net. And the triple net is the taxes you pay and the maintenance on the building and every other cost that the landlord has in maintaining his building. That all comes in its operating costs. And sometimes the operating costs can be the exact same as the rent. So if you're paying $500 in rent, maybe you're paying $500 in operating costs too. And so that's why your check's $1,000 a month. So what I've been looking around everywhere is trying to figure out if gross rent includes operating costs. And I can't find that. Everywhere you look on the website and commentaries, it just keeps saying gross rent. And I know if you've got like a well-crafted lease, a commercial lease agreement, which is the kind that we do around here, you'll see the definitions of rent are there, and there's a definition of operating costs, and we call that sometimes the monthly payment, but we don't ever call it gross rent. It's not defined as that. So that's a question I have, is what are they going to do about gross rent? So there was a lot of, I was reading in Ontario, because Ontario came out with, the provincial government came out with what was called CECRA, with an Ontario in front of the CECRA acronym. And there was a mass confusion because Ontario had put in certain things like profit issues and, what you could and could not put as operating. And that lasted about 30 days on their website before they withdrew it and said, okay, well, we don't even know what it means. But that's the kind of thing that came to me. I went, okay, what does that mean? I became concerned because I'm now wondering, like, what do I tell my clients who are tenants about what exactly gross rent is? Part of me says, well, it's not the tenant's problem because it's the landlord applying for it. But what if you get a landlord saying, well, I'm only going to apply for the rent, but not the operating. So I still want operating from you plus 25% of the rent. Could be an issue. So remedies, well, what can you do to make all this happen? Well, not a whole lot, because if your landlord won't participate in the program, there's really nothing you can do. I thought about remedies, like oppression remedies or injunctions, like demanding they do it. I don't think there's any stick right now. And there's nowhere to go in case you wanted to wield that stick, because the Supreme Court is closed indefinitely. But that's where you would go. That's a jurisdiction that, as a tenant, you would go to try to make something happen if you want some injunctive relief of some sort. I know I should note the Law Society is warning, and Martha will have got these as well. They show up in our inboxes all the time, every day. They're warning lawyers to engage in online filings of notices of civil claims and things like that to avoid the rush when the courts reopen. So I'm thinking the courts might reopen relatively quickly. I think, well, maybe we've got it to perhaps, even next week, we might get something that says the courts are going to reopen. That's not good news for tenants. I think it's better news for landlords who are looking to exercise their remedies against non-paying tenants or non-performing tenants. But currently there's no remedy for landlords from the court. So there's nothing they can do right now. If you're not paying your rent, there's nothing they can do. If they want you out, if they make demands, there's nothing they can do at the moment. But that should change relatively quickly. So that's the end of my presentation. Martha can do questions. That's where we are in case you want to get a hold of us. There's people, we're monitoring our telephone lines. That's our general inbox. If you go to our website, Haddock & Company, you can find all the details for us and a direct link to my own email if you had any questions. So I will stop sharing this right now, and we will go back to this.
Great. Thanks, Grant. Lots of food for thought in there. First of all, I had a question, which is there any judicial consideration of the term gross rent?
I know what, I didn't look it up, but I know that if I had to, it's going to be contract specific. Because if you're going to, I think if I did look it up, I would anticipate that every single question about what's gross rent would turn on the terms of the contract itself.
Exactly.
Yeah.
Yeah. So that would, we do have some law students who are participating in today's webinar, and that would be a very helpful thing, I think, to perhaps have a look at, because the issue, first thing, as soon as you started talking, that I thought of was the operating costs, and how actually difficult it is for particularly small nonprofits to manage those costs as well as the rent. So, and so for those that have had to considerably reduce their activity, this is going to be, I think, a major consideration. The other question that I had was, and may not be the most frequent in the sort of nonprofit space, but what if you don't know who the actual owner is?
Yeah.
Right. There's the offshore owner issue, but there's it's a numbered company.
Yeah. Well, like you and I know that what you do is a property search of the property, and so if you got access to BC Online, you can do that instantly, and you could use a civic address, and so you can go into land titles in New Westminster, and then you can pull the title, and the title will tell you who the owner is. And if it's a numbered company, you go, okay, well, that doesn't tell me much. And so there has to be an address there too, because that's where all their tax assessments get mailed. Land
Right.
titles will, so an address. The address doesn't help you either. So then the next thing you would do is you would do a company search, and that company search would give you the actual registered address of the company, but it would also give you officer and directors' names or local attorney. Because if you're an offshore company, you have to be registered to do business in British Columbia. So that would give you an address for probably a law firm most times, 90% of the time it's a law firm. Right. Now it gets a little stickier when you're dealing with a limited partnership, which I've seen before, because then the limited partnerships are usually owned by companies. And then you got to keep going down this line of inquiry to figure out who your guy is. And then forget it if you got a trust, because the trusts are, there's nowhere to find who's involved in the trust. So those ones usually are kind of a dead end, and you end up sending letters or demand letters to whatever address is on the land titles for the trust.
Right. So, and the likelihood that those folks are going to be the ones that are going to engage in this, I would imagine just that might be a limiting factor in terms of them actually seeking the rent relief. That would be.
It could be.
That sort of makes me very concerned. Anyway, so here's a question. Does the mortgage have to be on the building the tenant is in? What if the landlord doesn't have a mortgage on the tenant's building, but has a mortgage on a different building?
The way I read it, I think the mortgage has to be on the building that the tenant is in. That's, again, we'll know later. Same thing with the whole gross rent issue. I'm hoping that when the government finally comes out with telling us what they're going to do, they will define gross rent for us, and they will define what they mean by a mortgage on the property. Because, there's many different charges you can have on the property besides a mortgage. So a mortgage is, again, maybe needs some definition of what it is. Traditionally, everybody seems to know what it is. It's something you get from the bank that says mortgage right on it, but there's equitable charges that might cost somebody something, things like that. There's all sorts of things.
Right, or there could be liens on the property that, the lien wouldn't really.
A lien wouldn't, no, that's just a debt that they owe, but there's various financing vehicles that don't call themselves mortgage.
Yeah.
So I kind of wonder, I hope they're opening the door and say, there's a variety of financing vehicles, and it doesn't just have to be a mortgage.
Right. I have a friend actually who bought a property on their credit line.
Yeah.
And so there was no mortgage.
Yeah.
But they were paying it down through their credit line. So it wasn't a mortgage proper.
No. Well, you can, I've seen for the old equity co-ops, the pre-Strata Property Act co-ops, like the ones that are built before 1969, they are all shares and none of them own property. And so Van City takes what's called a hypothecation agreement, which is they take a charge on the shares.
Right.
So technically the whole place is mortgaged up because all the shares could be, taken by Van City and a foreclosure type thing. But if you've got a company that owns it, and instead of putting a mortgage on the property, your financer took a charge on the shares, you'd never know that. But it certainly would be a financing issue.
Right. So there could be some particularities as this moves forward.
There could be. Yeah.
Another question is, and this is actually very common in the nonprofit space, which is, what about with sublease agreements? So you're a sublessee.
Mm-hmm.
Let's say, you know, you're a nonprofit operating on Granville Island, and somebody has the grand lease, and you're a sublessee. So you're selling crafts out of a piece of property that is actually leased by CMHC to somebody else. Then it would be, I guess, CMHC that would have to be the owner of the property that would be seeking the rent relief.
Yes.
Not so if you're in a sublessee arrangement, you're not going to get, so yeah, I guess what's the answer?
Well, I don't think sublessee is going to matter, because CMHC, they'll just go down the hall and hand money to each other. So since CMHC is administering the program, but CMHC would make the application, I guess, and the tenant is the one that would, but the money doesn't go to the tenants, of course, right? I mean, the landlord only has to say, I have a tenant. It doesn't really matter if you got sub or sub tenants. I just have a tenant, and that tenant has to show a 70% reduction in their income in the reporting period. So if they, say for instance, a tenant, their operation, craters, they've got 6 subtenants who are making out like gangbusters because they do takeout food. Well, they probably haven't gone 70% down in revenue because they're getting revenue from the subtenants. So you wouldn't apply, or you wouldn't be in the bracket to apply.
Right, but I'm thinking of artist studios. I'm thinking of art galleries. I'm thinking of various sort of arts-related entities where you're very much at a remove from the owner, and even some of the major arts organizations are in like leases with the CBC, for example, on the 110 Arts, which is the post at 750, is in a building that is I think the owner is the CBC. Anyway, the mind sort of starts to boggle at the complexity of this when one really starts to think about it.
Yeah.
Another question here is the 50% coverage of the cost of the mortgage, or the cost of what the landlord charges for rent?
The cost of what the landlord charges for rent, whatever gross rent ends up being.
Yeah, and I think that's something that we can also look for we're putting together an info sheet that will have more information as it becomes available. But I think certainly what the definition of gross rent is going to be a major consideration there. Mm-hmm. So another question about what does it matter if the property owner is a nonprofit society?
No.
No,
I don't think so. Just got to be a landlord, got to have a mortgage on your property, and got to have a tenant that has a 70% reduction in revenue.
Right. So if you own the building and you have a restaurant that's in the building that has had to close entirely and is unable to offer takeout or do anything, then its revenues have declined significantly. Then you would be eligible to apply. This could be, though, of one of those situations where your tenant just walks away, right? Because I'm thinking of like the example you gave of the restaurant. There are a number of cafes that operate in buildings that are run by nonprofits, right? Whether it's in North Vancouver, for example, you've got the Presentation House, where Presentation House Gallery used to be. But that building is run by the theater, and they might have a cafe in there, and the cafe is bust and has no prospect of reopening, and this the margins being as limited as they are. But you wouldn't, I don't know, if somebody just walks away from the business, how do you get a rent reduction agreement? You don't.
You don't. There's no one to sign the rent reduction agreement.
Right.
Plus, tenants who don't even have the 25% of rent aren't going to sign an agreement, agreeing to pay the 25% rent. Can't pay even that. I don't even know how you'd prove it because, I suppose. So the deal has to be that the tenant has to pay 25% of the rent. Like how, I don't know how the government's ever going to prove that, like going down the line, that everyone adhered to what was supposed to happen.
Right. So this is interesting. The nonprofit society is actually co-owned. So the building is actually co-owned by 13 nonprofit societies. So then they're not tenants.
No, they're owners.
They're owners. So.
Oh yeah, they're basically owner operator, which wouldn't apply. Right.
So, but in the case of the restaurant that's owned privately in the building, because there's a follow-up there, which is what I was actually thinking of when I mentioned it, knowing that I know there, the society would apply for the rent relief, assuming that you've got a rent reduction agreement with the with the restaurant owner, and then you would apply for the rent relief.
Yeah, just with regard to whatever rent the restaurant was paying.
Right.
But if that's only a small part of your operation, and you co-own the rest of the building, you're only going to get that small amount of money.
Right. So it won't be for it won't benefit any of the other small nonprofit societies, except the benefit, I suppose, of being the owner operator is that you can decide, well, as a collective, well, I guess, no, you still have to pay the mortgage.
If you have a mortgage, maybe they're lucky enough and don't have a mortgage.
Right.
But to me, the banks are working with everybody, especially the commercial side.
Yeah.
Not so much residential, but the commercial side, they're being flexible. But again, they're looking, if you want to get like a mortgage holiday, I guess call it, the banks are more than willing to do that, but they are only willing to do it on principal, not interest. That's what I've seen anyway. I've rarely seen them say both. So typically everyone's looking for the lowest payment they can make over the longest period of time. So your principal interest is about equal. So if you're paying 10 grand a month on your mortgage or something like that, then only 5 of it's probably principal. So you still got to pay 5.
Right.
So it's not the holiday that people were talking about. Not really.
Right. Right. So this is coming up a lot in the lead up to this session, and also after the last one we did together, Grant, is, so what if the landlord isn't interested in applying? What do we do as tenants?
Well, nothing right now. I mean, it looks it's completely voluntary and in the hands of the landlord. So that's what I, keyed in on at the very beginning is here's the first big problem. It's landlord driven. And it shouldn't be, it should be tenant driven. I don't know what they were thinking when they said, let's leave it landlord driven. But what can you do currently? Like when this thing rolls out, my advice right now would be nothing. You can't do anything. The only thing I think you probably do is go to the media. I mean, that's one thing to do. Get active about it. If your operation is something that's community driven or an asset to the community, then that media exposure might actually work to shame the landlord into doing something. If you're dealing with someone who doesn't even live here, that they're somewhere else, or it's somebody who's Brookfield Asset Management or something like that, which is in Toronto, New York, well, they're not going to care really about this sort of thing. Right. So at the moment, there's really nothing you can do about it. I'm hoping that the government is listening, and if they're paying attention, they're looking at the websites of various commercial lending or commercial leaders, and they're and law firms and commentators and the CBREs of the world and all of that, or if they're looking at that sort of stuff, they're hopefully seeing what I'm seeing, which is that this is not a good idea to leave this in the hands of the landlord, because it's not a program that, if I had to like worst case scenario guess, like what if only 45% of the landlords who could take advantage of it? And that's a real possibility.
Yeah. Yeah, and I think that there's a whole lot of small societies, like particularly in the downtown east side. There are people operating out of, with leases that I've seen that are cobbled together by God only knows who. It's an open question if they're even up to date on their taxes. And there may even be an intermediary who may or may not be, able to negotiate very well with the owner. It can get quite complicated, particularly where the owners are offshore, right? But it's not unique to particular communities. It's meaning language groups. But I've had situations where the owners can't communicate in English, and there's a problem, and you need to sort it out. And the intermediary, who may be a son of the family, but not sophisticated enough to figure out, not willing to get a lawyer involved. That asset, that one building in the area, is their only income generating property, and they may not be very sophisticated landlords. I think this is also an issue to be taken up by the people that are in government relations, that are working within the nonprofit sector. Our next webinar on the 27th is going to be talking about Lobbyist Transparency Act. And I think it's incumbent on the nonprofit sector, if this is a big enough issue, for us to really get in front of Selena Robinson and whoever else to say, we really are going to need some additional relief, or this is a more significant problem than you realize, particularly for nonprofit societies that are quite small, operating very much like a small business would, but without necessarily the clout of the Independent Business Association or the restaurateurs or even Landlord BC. They don't, they're not going to participate in the tenants union, because the tenants union is residential tenancy, and people get confused, Yeah. So we have a very specific question from a viewer, and I'm going to remind everybody that this is a legal information session, not a legal advice session. And to get very specific advice, you really would need to consult a lawyer directly. The question, though, raises a couple of issues which I think are worth canvassing for this audience, which is some nonprofit societies may be operating out of buildings that are not actually zoned to be doing events out of, for example. Okay. So they're actually they don't have a business license. They are running a business out of a space that is at ground level, but not zoned commercial, say.
Well, I don't think anyone's watching that, and that's not part of the equation here. I've had people ask me about that, like in the residential tenancy part of it. There was a great fear that of tenants who were in illegal suites, and there's plenty of them out there, that somehow BC Housing, who's administering the residential tenancy subsidies, would get the information of this illegal suite or a list of everyone who's applying to the government, or local governments would then close down legal suites. So the provincial government then came out and said, we don't care where you are, if illegal or not, go ahead and apply. And BC Housing is not giving this information out to, the application information out to anybody. So that made tenants and landlords and tenants much more comfortable if you had a legal and illegal suite for people to go and apply for it anyway. Now for zoning and stuff like that, or carrying on operations that you shouldn't be carrying on, the application process doesn't require you to tell anybody what it is you're doing, or what kind of, or whether you're zoned for it or not. Because don't forget, the tenant is not making the application. Only the landlord is currently. It's a landlord. And all the landlord has to do is say, I have a tenant, I have this agreement in place. The tenant's lost 70% of their income, and that's it. Not what you're doing, where you're doing it, or how you're doing it, or whether it's legal or not.
Right.
So I think that is going to be a non-issue. And I don't believe anyone's going to look around at who's doing what or take the time to do it. So I wouldn't be worried about that.
Right. So I think the moral of the story is, if you have a good relationship with your landlord and you can document that your revenues have gone down 70% or whatever it is required, then your landlord would make the application, not you, the tenant. And likely then you would be able to negotiate some rent relief. That being said, it's really important to remember, and I guess we'll just have to keep highlighting this, which is that you do need a rent deferral agreement or a rent reduction agreement in place with your landlord in order to qualify for this, for them to qualify for this relief. And that will raise some issues for some small landlords who may let the DIY space do whatever it wants as long as they're getting their rent paid, but they may not feel comfortable with making these kinds of applications or spending money on lawyers. And further to that, we did make available the rent deferral agreement that Grant drafted, and we sort of cobbled together a commercial version after the last webinar we did. It is very bare bones, but it is a starting place if you've got that relationship with your landlord to say, hey, we can help here. Here's an example, here's where we could start with an agreement in place to get that rent reduction. And I think it's really important to start having that conversation, particularly if it looks like we're in this for another couple of months for some of us.
Yeah.
And I think also, if there is another outbreak or spike or whatever in the fall or winter, which is what the numbers would appear to suggest, getting some of these things in place now, or at least opening up this dialogue, could help out. If you've managed to get through this period and you're okay to reopen and things are, you know, it's obviously been awful, but things are going to be okay for a few months, but be prepared for the possibility of this happening again, and thus you may need that rent reduction in the fall. So open up those lines of communication with your landlord. The sooner the better. So the one last question here has to do with publicly owned facilities. And I don't know if there's been, I've been wondering that myself, if the city of Vancouver has simply told its tenants that you're all off the hook until this is over, or whether anyone else has taken it upon themselves to seek this out. I personally think that if you haven't done so, you should be doing so with our municipal and other publicly owned facilities. But I don't know if you have any light to shed on that, Grant.
I've only heard from one potential client who phoned me about City of Vancouver lease, and their report to me was that the City of Vancouver was not compelling them to pay at the moment. Understood completely that they couldn't carry on operations because their work entailed, having audiences and things like that. So not going to happen, and that was all their revenue, and they had a big rent payment, surprisingly big rent payment, but this was like last month. So, but they weren't being compelled to leave or to pay anything.
Right, but it would be interesting to know if the city is going to forgive the debt incurred. I simply put that out as a question because it is, again, one of those issues that the community as a whole should be seeking and demanding a certain level of transparency on. There's a lot of groups also that are sub-lessees to city-owned property. And our rent also should be forgiven, I think. And it is an issue that I think more and more people should be raising with their landlords across city-owned property, at least.
Yeah.
So we are now at 12:57, and it's probably a good place to stop. We will update our info sheet. I think we'll wait on putting it out to everybody until we see what happens maybe over this long weekend. And invite everyone to let people know about our next webinar on the Lobbyist Transparency Act, as well as all of the resources being up on our website, pacificlegaloutreach.com, and like us on Facebook and all the socials, because we're also trying to make the case, people, that legal information, legal education, and legal advice is really important to the nonprofit and art sectors across the province of BC and beyond. So thanks again for giving us your lunch hour today, Grant. Yeah, and thank you all for your attention today. Great.
Thanks for having me.
Bye.
Bye.
Bye, everybody.